Are you ready? And I'm recording.
You're good, Janice?
I'm good. I'm recording.
Okay. Good evening, everyone. This is a regularly scheduled meeting of the Township of Montclair Planning Board. In accordance with the New Jersey Open Public Meetings Act, adequate notice of this meeting has been provided by posting a copy of the notice on the first floor of the municipal building and by sending a copy to the newspaper designated by the township for these notices. Electronic notice of the meeting is also provided through posting a copy of the notice on the township's website, along with meeting access instructions. And the same is also posted on the main access door of the municipal building. The meeting is being broadcast live on Channel 34 and is being streamed live, as well as available on demand on YouTube. This meeting is a quasi-judicial proceeding, meaning the board has powers and procedures resembling a court of law, and we're obligated to objectively determine facts and draw conclusions from them in order to provide a basis for official action. Any questions or comments must be limited to the issues of what the board can legally consider in reaching a decision, and decorum appropriate for a judicial hearing must be maintained at all times. Members of the public are automatically placed on mute, excuse me, until such time as the meeting is open for public questions or comment. At that time, the members will be unmuted so that they may provide verbal questions or comments as appropriate. Members of the public may also direct questions or comments to Ms. Talley if being able to take advantage of the audio connection is not possible, and they can do this via the chat or question answers, or as a last resort by emailing Ms. Talley at jtalley@montclairnjusa.org. That's JTALLEY at montclairnjusa.org. The first thing on our agenda this evening, as usual, is our roll call. And I'm here, I think.
Okay. Vice Chair Broddock.
I'm here.
Mr. Cook is excused. Mr. Graham.
Here.
Mr. Ian Wally.
Here.
Ms. Blackman. Carmel, you're muted.
Here.
Okay. Councilor Schlager.
Here.
Mayor Spiller.
Present.
Ms. Willis. Oh. Carol, are you? I think,
I'm on the phone. Can you hear me?
yes, I unmuted you. Okay, so you're here. Mr. Gilmer
Here.
and Mr. Jacobson.
I am here.
Okay.
All right, we have the minutes from our June 7th meeting.
And we had the minutes with comments from Ms. Lockman and Vice Chair Broddock were distributed. Are there any additional changes to the minutes?
Did you make note of my presence at the meeting?
Yes, I did. Any other changes? Is there a motion to approve the minutes as amended?
So moved.
Second? All in favor?
Aye.
Aye.
Opposed? Abstentions?
I abstain.
Okay, Chair Spiller and Councilor Schlager. Okay. Okay.
All right.
What I'm going to,
Amen. Go
that
ahead.
leads us to the discussion on the master plan. Let me pull that up. And Carol, you just for now because there's an echo. And I'll unmute you after I've finished the presentation. And if everybody else can mute themselves so that the audio quality is maintained. So this is a public hearing to amend the Unified Land Use and Circulation Plan. This reflects recommendations from the planning board who evaluated recommendations in our adopted plan that called for changes to the zoning ordinance, to the zoning map that were not adopted. Tony, I'm gonna mute you. I hope that stops the, yeah, I think now there's no echo. And based on our discussion, this second slide really just is a summary of our existing zoning categories in our zoning ordinance, not in our master plan, because the master plan has different nomenclature for the land use districts than we actually have in our zoning ordinance. Just as a reminder, we've talked about this before. These are the different zone categories, at least the non-residential zone categories in our master plan. And really, the planning board, after reviewing the land use plan recommendations in the zoning recommendations in the master plan, consolidated or making four recommended changes to the master plan. One of them, the first one that's shown on the screen, has to do with a proposed land use district in Upper Montclair. The master plan calls for, and you can see this area up here, creating a new district for the section of Upper Montclair where the Acme Shopping Center is right here, and the adjacent 7-story apartment building. The master plan calls for putting this in a separate, or establishing a separate zone category for these properties that would include increasing the height from 3 stories to 5 stories, increasing the density from a maximum of 28 units per acre to a maximum of 50 units per acre, in exchange for appropriate public benefits such as parks and open space, affordable housing, and similar public amenities. After discussing this component of the master plan, the board felt that that proposal would create too much development intensity at this location. They felt it would be better to have something that was more in scale with this area and that would preserve the existing grocery store that we have, yet allow for reasonable modifications to that site so that it could fit in with the walkability of the rest of the district. And simply keeping it in the existing NC zone, which would allow for up to 3 stories of mixed-use development in this location. Right now, it's a 1-story building with, I guess, some basement uses. Was more appropriate, and and in order to move forward with this, we'd have to change the master plan to eliminate this recommendation for the NC5 and put it back into the NC district. So that was the first recommendation. I'm going to go through all 4 recommendations in this slide, and then I'm going to pull up the actual master plan pages that correspond to what the recommendations are. In Watchung Plaza, there's a couple of recommendations that the planning board has. The existing master plan calls for expanding the neighborhood commercial district to include this area here, which is right now zoned R2 residential. See down here, this is the existing zoning. And it contains residential uses, 2-family uses. So rather than call for the expansion of the NC zone at this location and creating commercial uses across the street from residential uses, as you can see across North Fullerton Avenue and across Fair Street, those are residential uses. Planning board felt it would be more appropriate to keep these properties in the existing R2 zone and eliminate the recommendation to change the zoning to essentially NC. Similar, you see this property here, we didn't draw a circle around it, but this property in our existing master plan recommends that it be zoned NC. However, right now it's in an R2 zone, R1 zone, and it's used for residential use. I don't know if this is the photo of that area or not, but this is an existing residential use. And so the planning board recommends to keep the zoning in its present R1 zone district, which is the same as its current use. The final recommendation, that was it. Those were the only two changes in this area.
I think those are two families, right? You said R1. I'm pretty sure those are two family homes. It might be
Down here,
hard to see.
these are two family.
What's that?
These are two. Can you see my cursor?
Yeah, so they're saying R2, not R1, right?
This is R2, right?
R2. Okay,
I
that's great.
believe this one, this
Yep.
piece here is R1.
Yeah, like the orange color. Got it. Yep.
Okay. All right, moving on to Lackawanna Plaza. The master plan right now calls for this property here, which contains essentially office and retail uses and a one-story parking deck at 1 Greenwood Place, at 1 Greenwood Avenue. That property plus this piece here, these three properties in the plan are recommended to be put in the C3C zone, which has a maximum height instead of 6 stories, it brings it down to 4. Because there's so much flux.
Is it 4 or 3 in the C?
I'd have to double check that.
I think it's 3 according to the master plan, but I know you said they could be different.
Yeah, I think it's 3 also.
All right, I'll have to double check. That is 3. Essentially, it's what we have in this area. It might be 3. I misspoke.
Yeah.
So anyway, the proposal is to not put these two areas in a separate zone district, but keep them in the existing C1 zone, essentially because this whole area is in flux right now. We don't know exactly how the Lackawanna Plaza property is going to be developed. We do know that the current owner is working on new plans for this property. And I think the planning board had decided that it would be best to keep, rather than make this change right now, because we've tried in the past, this zone change was not made previously. The planning board's recommendation is to keep this in the existing C1 zone and wait and see what happens in the Lackawanna Plaza area before making any changes to the zoning in that area. And then the final change is at Walnut Street and Grove. The existing zoning, as you can see, is a combination of C2, NC, and R2. This area that's highlighted is currently I think has been developed with a 2-story mixed-use building. And so the recommendation is to change the zoning because it's one project. And rather than have it in 3 different zones, put it all in the NC zone. So those are the recommendations from the planning board. This is the memo that was distributed to the board in preparation for tonight's meeting. What I have included in here is an identification of the properties that are where we're going to be changing the designation in the master plan. For instance, Lackawanna Plaza would go from C2 to C1. The property is identified in Walnut Street.
And I think that's an error. I think that it's supposed to go in Lackawanna Plaza. The changes are from C2 to C3.
No, they're not. If you'll hold on, let me go get to the map, okay? Lackawanna Plaza. These properties are now C1. Not right in the master plan calls for it to be in basically C2, And we're putting it back into the C1 zone district, which allows, the C1 zone is where we intend the higher development, very similar to what's over here at at Seymour Street, not the edge.
Now I just got confused.
Yeah,
I thought that we were just talking about leaving these in C3. So if it was proposed to go into C1. This doesn't say what it was. So if you go back to your presentation, I just heard that.
exactly. You look at our
Okay.
presentation that we saw when we were
Yeah.
looking at this, it's different.
The unified plan right now calls for C3C. Okay, the recommendation is to rezone properties from oh, that's wrong, you're right, to C3.
So we're
Yeah.
supposed to leave C1?
That's what the unified plan, the unified plan calls for rezoning the properties from C1 to C3. The committee wanted to amend it to eliminate the zone change and keep it as its existing C1 zoning.
And the committee,
Carol, yeah, go ahead, Tony. And then after Tony, I see Carol was trying to make a statement.
no, you're on the committee. Go ahead.
Carol, yeah, Janice, I don't know if you can unmute Carol.
I'm going to unmute her.
Hello?
Yes, so Carol, you're unmuted.
All right, and I think I should best stay unmuted for the discussion because I do want to participate in the discussion. I'm concerned that it would be premature. I would like to see it remain as we recommended at C2. I really do not think it's a good idea to change the Lackawanna Plaza to C1, especially because it's under development and it allows the building height to go from the present height of 3 or 4 stories up to 6 to 8 stories. It allows the number of units to go up to from a maximum of 55 to a maximum of 75 units. And I do not think it's a good time to allow that kind of discretion to the project, which is really very much in development at this particular time. I would prefer to not allow that.
So what you want to do is keep the master plan recommendation as it is, which is, because right now those properties are zoned C1.
Which is C2,
right now,
no. I'm saying that we had a recommendation to make it C2, and I do not want to leave it as C1.
Okay. It's not C1 right now in the master plan. It's
Right.
C3C.
And you're recommending that we leave it from C2, which is a recommendation, to C1. And I'm suggesting that that is not what I'm in favor of. I'm in favor of having a C2 designation there, particularly as the whole area is under development.
Okay, there's by C2. Are you let's talk in zone districts. Let's talk in, so that we're in the land use districts. Okay. So you want not C2 because C2 is the zone district for C2 is over by Walnut Street. Under the land use plan, you want it to be Montclair Center downtown C2, which is.
What I'm saying is that I'm looking at your recommendation for Lackawanna Plaza. And your recommendation says on the form that I'm looking at that you want to change it from the C2 to a C1. And I'm saying I do not agree with that change.
I know what you're saying. So I'm looking at the master plan, and I want to differentiate between the zone districts and the land use districts in the master plan. Okay, so these are, if you look at what's on your screen right now, these are the land use districts. So the area along Glenridge Avenue, which is actually the C3C zone, these properties currently in the master plan are in the C3C zone, this red area. The C3 area. And that's it's 3 stories. This area here is C2, okay, in the master plan on Bloomfield Avenue. It recommends 4 stories. But it's still the C2 district. We recommend in the master plan to reduce the height from 6 to 4 stories. That did not take place, but that recommendation is the same. So my question is, do you want these two properties in the same district as Bloomfield Avenue, where the master plan calls for 4 stories? Or do you want it in this red area, which calls for 3 stories?
I want it in the red area that calls for 3 stories. I'm saying that I'm looking at page 82 of the master plan and page 83, in which it describes what those heights are. And I prefer to keep it at a lower height than to allow the discretion to be taken away from the board, and that it should be allowed to be 6 to 8 stories. I'm looking at the description of what it means to be in C3 and what it means to be in C2 and what it means to be in C1.
So what we do is we'll put this in the C3 district based on what you're saying.
I'm saying that I'm looking at page 82 of the master plan. Now, if I'm wrong in looking at page 82, then I need correction. I'm looking at page 81 and page 82 of the master plan.
And that's, what district do you want it in, Carol?
I'm saying that I would prefer to see it in C2 than to see it in C1.
Okay, C2 permits, C2, which is Bloomfield Avenue area, which permits 6 stories right now, but the recommendation is to go down to 4 stories in the C2 district.
Right. I wanted to see it at 4 stories. I do not want to see it at 6 to 8 stories.
Okay. So you wanted to say, then that's different than C2.
I'm sorry.
That's correct. I do not want to see it increased to be eligible for 6 to 8 stories as a right of builder. I want to see it at a lower height.
Okay.
I'm still just a little confused. I thought based on the presentation that we looked at, it's currently in the C3.
It is.
Which is 3 stories. And why don't we just leave it at that? Why would we even raise it to 4 and then, incrementally, I guess someone might try to raise it to 6? Why don't we just leave it the way it is at 3 stories?
Well, we can leave it at 3. I'm just looking at the recommendation that I received in the mail for this meeting, and it's recommended changing it from C2 to C1. If it's C3 now and it's at 3 stories, fine. That's good.
Yes. My point is the subcommittee looked at this presentation and it was shown to be C3, 3 stories. And now it seems to be changed already in your memo to go to 4 stories. Leave it the way it is at 3 stories.
That's okay. That's fine.
That's fine with me.
Then we'll put it in the same. We'll leave it the way it is. Right now, the master plan has it in this, but it's essentially C3. We'll leave it there. We don't have to touch it.
Okay, that sounds fine. I'm just going by the memo, and I had perhaps been misled.
Okay. Well,
And if I could just clarify, we're talking about.
Leave it in C1, which is currently zoned C. That was my understanding. So I apologize if I misunderstood your recommendation. Tony, what you
Chair Wynn, I believe you're
I
on
was just
mute.
about to clarify that. They're currently zoned C1, you're right. And the master plan looks to make it C3. We're leaving that the same. I have a question. What did the master plan say about Lackawanna Plaza itself? It seems like since it's all grayed out there, the assumption in the master plan was that it might eventually be put into a redevelopment area. Can you shed any light on that?
Yeah, that's a proposed redevelopment area. That's what the color means, redevelopment.
Yeah. And the corner property there, the purple area is not in the redevelopment area, or is it in the redevelopment area?
This one?
Yeah.
That's not in the redevelopment area.
Okay. And then last question, the previous plan for Lackawanna Plaza did not use a redevelopment area plan. It didn't use a separate redevelopment zone, right? It was just as of, whatever the existing zoning was.
You mean the site plan that was
Yeah,
approved?
the site plan was put forth.
Yeah, they came in under the existing zoning rather than.
Okay, thank you.
It started out as a redevelopment plan and then they changed their tune.
Got it. Thank you.
I just have a question for you, Janice. So the purple areas that we're talking about, right now in the zoning, they could be 6 stories.
Yes. All of this area in the zoning, these are all 6 stories. This is 6 stories. This is 6 stories. Well, this is redevelopment here, but yes, all along Bloomfield Avenue, it's 6 stories.
So
But the
basically,
master plan proposes that they be
4 stories.
3 stories.
I understand that, but right
It's 4
now,
stories
4
on
stories.
Bloomfield Avenue.
but right now, anybody could go in and build 6 stories. So we're not, I mean, the master plan is a guidance document, but the ordinance is they can build up to 6 stories.
Right.
Ordinance hasn't changed yet. No.
Yet, I mean, is the next step, once this master plan change is adopted, that the zoning would follow suit?
Carmel, we will try again. I tried before in 2018, and the council at that point did not elect to move ahead with changing the height in those districts
Okay,
along Bloomfield Avenue.
so the only exercise here is to make sure that the master plan agrees with what the zoning Board of Adjustments has kind of recommended, that we align the master plan with what is actually happening.
No, I think that the point here is I want when I move forward with the next round of zoning changes, I want to make sure that the planning board is on board. You said we need to
Okay.
reevaluate the master plan. We're doing that before we move ahead with the zoning changes to make sure you all are comfortable.
Yes, I get it, Janice, thank you.
All right. We talked about Watchung Plaza. We talked about Lackawanna, which I will keep it in the C3, in C3 from the master plan. And then the final one we talked about was Walnut Street and Grove Street. So we finished that.
Can I just ask you a question, Janice, on Walnut Street? That is just that one property. Nothing else is changing there.
There's 2 properties. There's 2 properties.
Yeah, the two.
Was this one here, and there's a little narrow strip property right here that contains the car wash.
Okay, yeah, but they're one building.
Right, now this is the new proposed plan. They're all part of the district.
Okay, thank you.
Okay, so these are the changes that have changed. I'm gonna get rid of change 75 will be eliminated, going back to the way it was previously. Page 98 will be changed to just change the map here for these properties along Walnut Street. Watchung Plaza will be changed because all these properties I'm highlighting now with my cursor, will be taken out of the C4 zone district, as will this property here, because those are residential uses. And then Upper Montclair, as we discussed, the properties here, which were proposed for a C3 district, are now going to be in this C4 district. I know Carmel had a question about why all of these properties are in C4, they're not in C3. And that's because when the master plan was created, these are all commercial districts. C1 is the central business district with the taller buildings. And then there was C2, C3, C4, and C4 is the lowest density commercial district. So that's why the way it ended up in the naming approach that they had in the master plan, it ended up Upper Montclair Edge. And so the recommendations on page 148 in the master plan will be eliminated because that whole page talked about the C3 zone in Upper Montclair, which we're no longer going to include. And then we just made a couple of changes to page 150 to eliminate the references to that C3 district in the discussion of the street system. So essentially, there's only 3 changes. If we get rid of the recommendations for Lackawanna Plaza, keep it the way it is, there's only 3 minor modifications to the land use plan that we're making. Are there any more questions from the planning board about that, the changes?
I had a couple of detailed questions that I just want to make sure that we weren't, and specifically on the maps, to make sure we weren't inadvertently changing things that we don't intend to.
Okay,
If you could go to the Walnut Street map first.
okay.
On the upper left of that map at Oak Place and Forest Street, there are 3, I believe.
Forest Street up here?
Oak Place and Forest Street, yes. There are 3 properties on the corner of Oak Place and Forest Street that are highlighted in yellow, but if I look at what I believe to be the latest version of the land use plan, which was 2017, those are not highlighted.
We didn't make any changes to this area.
And that's consistent with what I think this board intends. But I just want to make sure that somehow we don't have, carryover with a new map where somebody now thinks that that's in a different land use zone.
Let me pull up a page. We're on page 98. Trying to pull the existing master plan.
Sure.
Because there won't be any changes to that area.
Oh, I see what you're saying.
Yes.
On page 98, those 3 properties are gray, where the other ones are, yeah.
Huh.
Spot.
I wonder how that happened. I don't know how that happened. I can't even tell because the quality of this map is so poor. Let's see.
It's pretty clear on my end in my copy of the 2017 plan.
Well, I pulled up the 2020 plan.
I may not have the latest one downloaded then.
But we didn't, there was no changes to that. That's why I'm surprised. Maybe this might be better.
Are we on page 98 of the existing plan?
Yes.
Okay, so those properties are carved out. Is that what you're
Yes.
talking about? Okay.
Those are the properties that are right next to the Montclair Bread Company. I guess.
Yeah, so those are gray. I don't know how that happened. So
What color should they be? You think
they should be the existing zoning. I don't know offhand what the existing zoning is, but it should be
The existing zoning is R2.
R2.
Yes.
So these should be eliminated. I don't know how that happened. Unless somehow we had to recreate the map as part of this.
That very well could be that we had to recreate it because we didn't have access to the original files that the original authors used.
Well, we did. I don't know. Like I said, I don't know how that happened, but I'm glad that you caught that. Did you see any other changes?
Yeah, I got a couple more.
Okay, go ahead.
I just wanted to double check while we're on this Walnut Street that it is, as we get closer to the area that we actually spent time looking at, it's only those 2 properties because on the slide deck that we reviewed, it looks like it's 3 properties were recommended by the zoning board of adjustment to be in the NC zone. If you go back to the PowerPoint real quick, Janice. Sorry about that. have you go back and forth.
No, that's okay. All right, I have to reload it. Somehow it's.
Oh, actually, you can even stay on that screen there.
This one?
Yeah, because it looks like you can see it where there are two properties fronting Walnut Street, right where your cursor is. And then there's that one thin one that fronts Grove.
Yeah,
That's the parking lot.
Now it is. At one time,
Yeah.
that was a house, and then there was the Enterprise rent-a-car on the corner, and next to that was the car wash. So there were three separate properties there.
And I
Right, so
believe they were consolidated with the most recent applicant approval.
That's
So
right.
it shows the consolidation and includes those three properties in NC zone district.
Okay. So if they're consolidated, that'll work. So I'm just looking at the text versus what was in the map. And the text on the memo had 2 lots, whereas it looks like in the zoning map, it's 3 lots.
Right.
So I just want to make sure we're clear about what are the two, which are the correct properties to actually zone. Because still on our township zoning map, it looks like it's 3 properties that we're now putting into that green block on the corner of Walnut, the south and east corner of Walnut.
That's why I think when our tax maps have not been consolidated, and so in the memo I said we're adding lot 9 and lot 11, which are right now in 2 different separate zone districts. So there'll be 3 lots. There's lots before were consolidated.
Okay. So that's good. It's just as long as we're accurate to what we're trying to do. And then if we go to Watchung Plaza, and these are pretty minor, but the Watchung Plaza, I would imagine the railroad is probably not included in this change and it still should be public.
Yes.
Same for, I think it's the parking lot that's at the very south end, that kind of almost like an L-shaped property.
This area here.
So that's one that I think should probably be colored public, but at the very southern end of the green, that kind of bottom green lot is, I think that's also a parking lot. Is that public?
This area here?
Yes.
Yeah. Okay. It probably is.
Yeah, so I think that's public and probably shouldn't be included in this map.
And the green itself, this area.
Sorry, that's what I mean. Yeah. Oh, yeah, that shouldn't be a development zone either. That should be public.
Should be blue, wasn't
Yeah.
it?
Okay. Got it.
Well, you have to make, Janice, don't you have to make allowances for, isn't there a business? The old, no, maybe not. Maybe I'm confusing this with
Not here. And
with
also
another piece.
this parking lot here in Watchung Plaza should be blue as well.
Correct.
Okay.
I think all of those would be public.
Yep.
Let me just double check that I didn't have anything else. Nope, those are all I had.
Wow. You must be good at Where's Waldo.
Also,
Well,
the,
you know what? I'm looking at.
Watchung Plaza, you know what, our zoning map is weird. Our zoning map, I'm looking at our online zoning map. Watchung Plaza itself, big green area, that zone, neighborhood commercial, right in the middle of the square, in our existing zoning map.
That's why we're proposing to put all the parks into a public. You see, this area up on Montclair, the parking lots are not in a public either. They're wrapped into this general C4 district. So I think what we need to do is carve out the parking lots and the train area, train station. The public use is essentially in Upper Montclair as well. To be consistent.
Can I make a recommendation that maybe we not go through this any longer? No disrespect to what's going on, but maybe have someone neaten everything up and then bring it back?
We can certainly do that. We can.
Because this is hard to do, you know, on Zoom.
We can continue. I think we need to continue at the public hearing to a specific date. We can look at the updated maps at that future date.
I mean, it would be great if we were live at that future date so we can look at this.
I can't. I don't know when we'll be live. I haven't received any information as to when we could do that. And there's an extensive notice requirement for this. So, I think the best thing to do would be just to carry it to a meeting. And we can say a meeting, and I'd rather do it in August and not continue this, because these are fairly simple changes. Let's do this at an August meeting, and we can move on from there.
Okay.
We do have to open it up to the public, though, because I do know we have members of the public here. But before we do that, are there any more questions from board members?
Well, I really would appreciate seeing exactly what the changes are, that with corrections are, graphically.
That's what we'll do.
Yeah.
All right, so I think. Okay, I think that I'm going to open this up to the public then.
Can you mute Carol if public is talking now so we can hear better? Please?
That's
Yes,
fine.
I can.
And I'll mute myself.
Okay, members of the public, I think I've unmuted you. So if anybody has any questions or comments about these proposed changes to the master plan, now's your time to speak. If you do want to, you are unmuted. Martin, if you want to speak, you need to turn on your audio.
Can you mute everybody else, Janice? It's very hard with these echoes.
Martin, I don't hear from you, so I know you did make a comment in chat. If you can't turn your audio on, you're welcome to add whatever comments you have in the chat function. We do have a call-in user. Call-in user number 4973746. You're unmuted. Okay. I don't hear any comments.
Janice.
Yeah. All right, you're
I have a different number.
Excuse me?
This is Frank Rebecki.
Hi. You're unmuted.
Okay. I have a couple of comments. I'm still getting an echo here, and I've muted my thing, so I'll try to work through it. I sent you an email in Upper Montclair. Can you confirm we're getting rid of the edge designation when we make this change to the master plan? So it'd be C4 Village. The other thing is I would like to, I forget which page it's on, but it still references the gateway, the Upper Montclair Village Southern Gateway.
Hold on, this is 46. Let me get to. Almost there. So this is the current master. So we have all of Montclair. The regular part of Upper Montclair is Upper Montclair Edge is in the green. The area where we proposed 2-story buildings was C3, Upper Montclair Village. So what we want to do is we're going to get rid of the Upper Montclair Village and put it all where we have 5-story buildings, put it all in the C4 Upper Montclair Edge, which permits up to 3-story buildings at 28 units per acre. Okay, so it would be C4.
C4 what then? C4 Edge or C4 Village?
No, C4 Edge, because the village has a higher intensity of development.
Okay, I think that's a mistake. I mean, this got screwed up back in 2015, and we never got straight. I think there's another page, 130, where it's even more confusing. That's not addressed here.
30.
I have no problem with the C4, and
You have a problem with the nomenclature.
the nomenclature, and you know, it's a different and the requirements are different from the other C4s in town, which I'm fine with. You know, I don't think C4s should be generic. I think they should have a certain amount of customization. But yes, change the nomenclature and kill. I think it's on page 146, 148. Kill the reference to the Upper Montclair Village Southern Gateway.
146. Yeah, 148 we eliminated. This whole thing was eliminated. Everything on page 148. Because this is the 5 stories. So we eliminated this whole page and just have this page.
Okay. But can you go down a little further?
To page 149, I mean 150.
Is there a reference still to the Upper Montclair Village Edge?
In the new plan.
In a paragraph form.
Okay, this is the new plan. And all we have is the C4. We don't have anything for C3.
No, it doesn't reference a zone. It just references the gateway.
Oh yeah, this is still here because I think this is still valid. Redesign of the A&P, now Acme Shopping Center and CVS, in which screening and greening the parking would improve this area. I mean, I think that's still valid. Building setbacks.
Well, I've always disagreed with the setbacks. You know, I think that there's wording in there that says 20 feet is detrimental to the character of Montclair, which I think is, I mean, it's crazy. I can't see an argument for eliminating a 20-foot setback in an NC zone. But anyway, my issue is we, as a township, as a nomenclature, as a philosophy, as a zoning philosophy, I don't think we should have internal gateways. We can have border gateways. You know, if you're coming in from Passaic County, if you're coming in from another town, fine. You want to have a gateway, have a gateway. But to have internal gateways between neighborhoods, and we have that really only in 2 places. We have that in Upper Montclair on the southern side. So, and we also have it on the south end on Cedar Street, which it just, I mean, in Upper Montclair is a big, I mean, we have diversity issues in this town. We have, you know, we have cultural issues in this town. And the idea that the planning board wants to build up some kind of gateway between neighborhoods it's a little bit insensitive, a little bit out of touch. And I think, there's nothing to be gained by keeping that paragraph. So I would kill off the paragraph without a doubt. And lastly, our zoning between the zones, whether it's R3, C3, C2, the whole idea was to have a natural transition between zones. Every time you say there's a gateway, you're basically encouraging an abrupt transition. You're not encouraging a seamless transition or a mild transition. So I just think we need to get away from the whole gateway concept. It's just wrong. So lastly, I just wanted to, these changes, I understand why we're making these changes, but there was an interesting conversation the other night between Peter Steck and William Harrison. And Peter was making the case that, the master plan said this is what we want to do. And William Harrison was making the case, well, that's very nice, but we've been having these recommendations now since 2013, 2014, 2015, and the governing body hasn't done anything about it. So his question to Peter was, which one should I weight more, or how should I weight them philosophically? Should I weight what the existing zone plan is, or equally to the master plan, or what direction would you give me, Peter? And Peter didn't have a good answer to that. And I was wondering, since you're revising the master plan again, do you have an answer for William Harrison, in specifically to an area that's a quite contentious area right now? But how does the planning board suggest zoning board and other land use board treat the stagnation between the master plan and the zone plan?
Well, that's a very good question, Frank. And I have to be honest with you, it's unusual for a town to have a master plan that is entirely consistent with the zoning ordinance, because quite often the plan, its recommendations are different from what the councils often adopt. I think we recognize there are inconsistencies. And so that's why we're going through this effort to try and discuss these things, focusing right now on the map, and then we're going to focus on particular zoning changes and see if we can eliminate some of those inconsistencies. Because honestly, we prefer not to have that. We prefer to have everybody agree and in line in terms of development. But there are instances where the master plan will recommend one thing and the council will disagree. And all we can do is, every once in a while, take another look at it, which is what this planning board is doing, and see if we can eliminate as many of those inconsistencies as possible.
And Janice, I appreciate that. It's just there are so few opportunities to give public comment to the planning board that I know I'm stepping a little bit outside the specific changes. It's only because it was an interesting conversation. It impacts what you're doing tonight. And there's been several conversations with Commissioner Gill and Fourth Ward Councilor Cummings about gentrification in a C3 zone. They don't want to see it. Matter of fact, one of them guaranteed it wouldn't happen. And, the planning board is actually advocating a C3 zone in some areas and taking away from others. So there's really a lot of disconnects between the governing body, the Essex County Board of Commissioners, and the planning board as far as what the master plan is saying. And I don't know what form I can use to get my comments in. I'm assuming I'm trying to do it in this form, but it might be I have to do it in the governing body's form. I don't know what you suggest.
Well, you know what? We have a follow-up conversation with tomorrow, and we talk about the best way to proceed. Clearly, the focus of tonight's discussion are the ones that were identified through our efforts. We did bring in the report from the Board of Adjustment to identify where some of these inconsistencies are. there's new ones that come up, we'll try and address that in a future date. It's not part of this round of changes.
Thank you.
And I see that Mr. Schwartz was not able to get his audio to work, but he said he doesn't need to speak or comment at the next hearing. And I'm going to mute are there any more public comments? If not, I'm going to mute everybody and try and eliminate the feedback. Okay. So I think what we need to do is come up with a date to continue this discussion. And right now, I would like to recommend that we do it for July 26th. And if anybody, I have one small application that night, and I think we would certainly have time on the agenda to talk about, these changes to the master plan.
Just out of curiosity, is there any indication of when we're going to be back in person?
No, we've been talking about it because it takes some time for us to get everything in place. We have to notice so far in advance, and there's been no direction given as to when we're going to go back to in-person meetings. As you know, we still have to social distance inside the municipal building, which makes use of our council chambers a little difficult, very difficult. So if there's no further comments, I'd like to continue this public hearing on the master plan to July 26th with no further notice at 7:30. It'll be a remote meeting. The agenda for that meeting will be posted on the planning board's webpage, and it will include the link to join the meeting. And then no further notice will be required. Okay.
Sounds good.
All right. The next thing on our agenda is a discussion of the planning board bylaws, which following our last meeting, I put the Tony's comments into format for the entire bylaws, showing how things were moved around. And I know Jeff Jacobson helped as well and made a couple of comments to the bylaws, and Carmel, I know you had some comments, but those were distributed to the board.
Janice, is everything on the hard copy that you provided or not?
Yeah.
Oh, okay, thank you. All the comments are on the hard copy, good.
I read through the changes that I made along with the additions, and it looks fine to me.
Okay. A couple of questions here. Arthur, are you there?
I am.
Okay. This question came up about potential conflicts. And
Do you have it on the screen, Janice? Can you?
It should be on the screen. Do you see it?
Oh, I do now. Sorry. Yes.
Arthur, do you have any comments about this one question, this particular question?
On 1:3-8.
Yeah, whether or not we need to define neighboring landowners, and whether or not the 200-foot rule applies, or are we being more liberal in the 200-foot rule?
I think that just speaking from a lawyer's point of view, neighboring landowner is so ill-defined. There's no definition for it. It could be as much as an abutting landowner or within 200 feet or even more. Yeah, I'm not really comfortable with that.
Well, I think that the current language is neighboring landowner.
Yeah, and I'm still saying it's not, unless you're going to define it, it's too loosey-goosey for me, frankly.
Because Arthur, that was my issue, is that one of my first meetings, I asked Janice, you know, I said, I'm like a quarter mile from this property. What does that mean? And I got an answer back that I'm fine because it was, I don't remember whether Janice said 200 or 250 feet. And so when I saw neighboring landowner, I had the same reaction you did, which is, the heck does that mean?
Yes.
So, I mean, I don't want to, it's not my intention to kind of like send us off on a legal issue on that. If we define it, are we defining it too narrowly or too expansively? But the term neighboring sitting there was not doing it for me.
I mean, I think clearly, Arthur, if a board member is within 200 feet, that's a conflict, and they have to.
And that's what the MLUL requires, that we give notice.
The MLUL requires 200 feet. You have to recuse yourself. Is that where that comes from? So why don't we just go with that?
Agreed.
Isn't the intent of this to not have a board member sit when their property may be impacted? And I think that you can be impacted at a greater range than 200 feet. So I think that in some way, the way it's written kind of makes sense, because, I mean, I think the intent is that if you're fighting your battle about its impact on your property as a member, the board member, you can't be there. You have to be in the audience, right? You can't be on the board. So I'm not sure if.
I mean, it's important to note that it says in at least the following context. I mean, the purpose of this bylaw change is not to kind of create a problem. It's to be illustrative. And so since we're saying at least the following context, if we define it as 200 feet, it doesn't mean that you don't have to disclose other conflicts. It just means that we're taking a term that means nothing and at least putting something in here that means something.
Right, and we're also reflecting that the governing body determined that people within 200 feet were the properties that were most likely affected by an application, and that's why they're required to receive notice. And so that's why we're relying on that definition. But agreed, it's not a be-all, end-all, and it would be very hard to come up with a number that covers every situation, Tony. I don't know how we would address that.
Yeah. Okay.
Does it make sense to change the wording to landowner within 200 feet? To make it a little more precise? Does that make any sense? And does that get at what you're trying to say?
I always thought it could be a real conflict or a perceived conflict. It's not a matter. I think definitively within 200 feet, yes, there's a conflict. But if it's farther than 200 feet, you may feel that you have a conflict for some reason.
We're all saying the same thing. I mean, we're all acknowledging that just because you're at 201 doesn't mean you're okay. If there are other reasons why, all we're doing is we're taking a term that doesn't mean anything and we're giving it some meaning, but we're also acknowledging that there are other reasons why you might need to recuse. If we want to say that, that's fine too. If we wanted to say this is not an exhaustive list and we need to recuse whenever we need to disclose other conflicts as they arise, that's fine too. It was the term that was, as I said, not doing it for me.
Well, there's a lot of other items in that sentence, like, how do you define personal involvements? So there's a lot of things that are squiggly in there. Or, relationships arising from business.
Right.
So you could buy a cup of coffee in some place.
Well, I think the guidance is that when you're in doubt, you should talk to the board attorney. And if you're still in doubt, then you recuse yourself.
Well, that's paragraph 2 in terms of talking to the attorney. The case law sort of addresses these issues. They don't define it, but case law does address these kinds of issues.
Like I said, I didn't mean to send us off into a philosophical debate. It was a term that didn't seem to have a meaning, and I asked if we should define it. If we want to define it, great. If not, if we want to leave it vague, because as Tony said, there's other vague things in here, and we all know that the goal here is to make sure that we disclose conflicts and recuse when we're in doubt. That's fine too. It's not a big deal one way or the other.
Doesn't the second sentence kind of do it for everybody? No member shall be permitted to act on any matter in which he or she has either directly or indirectly any personal or financial interest. Doesn't that kind of take care of without the neighboring landowner? Doesn't help to clarify that particular sentence, does it? I think it's sufficient.
That's just a different side of the same coin, Carol. Personal or financial interest is just two possible interests. There could be others.
Well, what I'm saying is that a neighboring landowner may be that personal kind of thing, since it's more than 200 feet. If you have some gripe with a landowner, even though he's more distant than the law requires, then that's a personal thing at that point, is it not?
Why don't we just say something like proximity, owning property in proximity to the subject, to the application?
I think that's but it might not, again, it might not involve ownership of property. It could be a personal relationship. Yeah.
Oh, I know. I'm just trying to address the one thing about neighboring landowner, which happens to do with proximity.
Well,
I'm wondering if we need the phrase those two words at all. I think it's kind of covered with the personal.
I think leaving it in its current open state gives enough leeway so that we're not restricting, we're not over defining it. We do have to a certain extent, rely on the members of the board to be professional and to, evaluate in a fair context whether or not they can be fair and impartial, or whether their presence sitting on a hearing is going to jeopardize that hearing. And neighboring landowner, I think through the notice, again, going back to the MOUL, it's not an exact defined term, but it does suggest that 200 feet is a minimum, that 200 feet rule is a minimum. And again, we can try and overanalyze this, but I'm not sure that we can come up with a better way to define this. I think there's enough here that makes it clear that if you have some sort of connection to what's going on, you need to recuse yourself. You don't necessarily have to be a neighboring landowner. You could be a neighboring resident, who says that you're not renting,
I think it's more than just recuse yourself.
I'll just take one more swing. Do you want to say neighboring landowner parentheses certainly within 200 feet, 10 parentheses? That way it's both. Yeah. Both vague and specific. And has the specific guidance so that we know what the minimum is. If you don't like that, that's okay.
I don't think that's a problem, adding that 200 feet. Yeah, I think that's what it means anyway. But if that gives you makes it feel better, yeah, go ahead. Let's put that in.
I like that because it's an actual rule. It actually is a rule. So there's no place in here where this is a very practical thing that happens. We all live amongst properties that could potentially be within 200 feet of us, and therefore we'd have to recuse ourselves. So we should actually reference that 200 feet somewhere in here. Because
and I'm sorry, did we want to say neighboring landowner or resident? As the chairman suggested,
I think that since we're going that extra step, yes.
Might as well, right? Yeah.
No, and just to be clear, the reason why I agree with Carmel on this is because the purpose of this document is to explain to the public what we're doing as much as it is to explain to ourselves what we're doing. And since the public is not going to go and read the MLUL. Better to put that rule in here so they get it. So that's, I think we found landed on a good place.
Okay,
I like that.
Agreed.
all right.
Looks good. Not a change to make here, but before we move on, for you, Art, on the business side, how do I phrase this? It tends not to include patronage. Is that right? So if you're a patron of a business, that tends not to. I just wanted a little guidance because, again, it's like if your child goes to a daycare or attends a school within a certain distance, how do you
See,
think about it?
I personally, I feel that if the applicant is a doctor who you go to, then you should recuse yourself. If it's a store that you shop at, that's a different kind of relationship. However, if you've got a personal connection with the owner of the store, if you're good friends, if you socialize, then maybe you want to consider again putting that off. I mean, we live in town, so hopefully we're being a patron to most of the towns or many of the town's businesses, so that it would, anytime something would come up with a local business, it would be very hard to for anyone to sit on that as a hard rule. But if you don't have a personal relationship with a store owner, then you shouldn't really worry about it, I would think. But again, if this person is a friend of yours, then you should think twice before sitting, on the application.
Yeah, those three made sense. So the personal relationship, clear as day, the financial interest where you may have, profits from this, or even, a stake, et cetera, or even employment where you're also receiving. So all of those are indications where you may be receiving something. Paying for services rendered, I get what you mean. If you have a personal relationship with that owner, you're very close, that's a little bit different. But as you mentioned, we're all patronizing, hundreds of businesses throughout town. And so, yeah, I did not think that simply being a patron would conflict you out, but it has come up before. And so just want to
say another example is if your office is in a building and you're paying rent to someone who comes up being an applicant, even though you have that business relationship with them as a landlord tenant, then you should be recusing yourself.
Yeah, I still think we're here with the wording though. I don't think we need to add landowner, resident, renter. I think we've covered it. Yeah.
So I think what these bylaws are really meant to do, in addition to defining those places where you should recuse yourself, these bylaws are intended to make you ask questions, whether you should, in fact, find out about a potential conflict, just as you just did, Daniel. I think that's their function.
Right. No, that makes sense. And the child going to the daycare every day is one that I do think, depending on the relationship, you'll probably know the director of the program very well. You might be paying as much as others pay in rent just for that daycare. So, okay. Yeah, that's helpful though.
Just as long as your child is not acting as the attorney for that daycare center before the board, you'll be fine.
Yeah. None of my children are quite that precocious.
Yet.
Okay, on page 7, we have a question here about whether we should address how board subcommittee meetings are handled, i.e. not open to the public in the discussion of open meetings.
Yeah, that was my question. We have a lot of subcommittee meetings, and I don't, why should they not be open to the public? I mean, sometimes it's impractical, but we need some parameters around that, do we, or not?
Well, we don't have a quorum at a subcommittee, and I think that kind of makes it operable. I think at some point we'll be unable to get work done if we overdo.
Yeah, I don't think those don't qualify as an open public meeting under the Open Public Meetings Act. That's just a working meeting for a subcommittee.
But should we
that's
mention
correct,
that?
and that's the answer.
But should we
because
mention- I mean, we should put it somehow in here that we have many subcommittee meetings where a quorum doesn't exist that are not subject to the Open Public Meetings Act.
That's correct.
Well, that's the way subcommittees are structured. That's why they have a limited number that you can put on a subcommittee, because you cannot have a quorum.
I know that,
And
but
that goes to that's how the Open Public Meetings Act is written, too.
once again, people might ask, and people do ask, why is the subcommittee not open to the public? So why don't we just have it in here and someone can say our bylaws say this? That's all, you know, I'm not.
But I think the statute covers it, right?
That's right, the statute covers it as well.
So you can, the response can simply be, Carmel, well, statutorily, it's not required, right? So it's more than the.
And it's also not practical. It's
And you
not
can also
practical.
say, that this matter, whatever we're discussing, is going to come before the board in an Open Public Meetings Act anyway. So that's your opportunity there.
Yeah, I was gonna add that point too, exactly.
Okay. No problemo.
Okay.
Oh, right there, one quick, just a little insertion. You see in B there where it says when communications by board members.
Yeah.
In C, just put by board members again. Just forgot it. When communications by board members.
Oops.
Thanks.
Okay. So here you want we had this comment, delete this sentence, which is board members are not permitted to comment publicly on pending applications except during a board meeting properly noticed pursuant to open. This is the sentence you want to delete?
Oh, are you talking, that was my comment. I thought that you should put that, you have a categorization of when communications by board members are not allowed. And I believe that sentence there should be the opening sentence of that section B.
So I put it there because it was my intention to kind of introduce B and C. That the point is that A was meant to say, look, we can talk about some things, we can't talk about other things, and then we get into specifics in B and C. And otherwise, the transition seemed a little abrupt. But
yeah, I just thought I can see what you're saying. I just thought it fit in B because it comes under the heading of when board members shouldn't be talking.
I think it works as an introduction.
Okay.
Let me see if there's any more comments. Okay, this one.
This is my comment as well. I mean, I really personally think using itself is, you know, it's trendy, it's happening, but from a grammar point of view, from a personal point of view, I really don't like it. But if everybody wants to put that in there, you need to be consistent within the document to say himself, herself, itself. We're human.
What if the applicant is an LLC?
Oh, is that what you're talking?
This wasn't gender neutrality. This was.
I thought it was. I was jumping on you.
This was corporate. This was corporate personhood.
All right. Sorry. Yep.
Look at themselves for the gender neutral. Yeah.
Okay. I stand corrected.
Okay. So we'll keep itself in there. And here, should we mention the HPC or do we have, we've always had it, our statute was written so that we always have a member of the HPC on the planning board. It used to be Steve Rooney and now it's Mr. Graham.
Is there any reason to mention that here in our document? That's all I'm saying. I mean, things that happen in reality, it's nice to have them also in the bylaw document.
I don't think we really need to have it in here.
It's in the ordinance, isn't it, Janice?
Yes, it's in the ordinance, so it doesn't really need to be in the bylaws.
Right.
You'd also have to add in the environmental commission representative too, if you wanted to add that in.
Maybe we should add that just for completeness. And if someone were new and they were reading how this operates, it would be nice to know that we have an HBC member, we have an Environmental Commission member. I mean, I look at this almost like a training document. You get a new member of the board, and if they read this, it gives them a good idea of how we operate. So why not mention our other land use people that help us out here?
I do see that. The only thought I had, because I started to read it with that lens also, Carmel, it's a really good point to make sure we're not skipping over things that would be really helpful for someone to read, you know, with the first pass. But I think you actually just have to read the ordinance and this document together. So I think there's a lot in the ordinance that we can't necessarily, because it does get to like the municipal, you know, the member of municipal employee, and then also, you know, mayor's designate. You start to get into almost replicating some of what's already in the ordinance. But yeah, so I would say just maybe keep it separate, but yeah.
The bylaws could be a good place to put in native plant provisions.
I would object to that.
The environmental representative will always ask about, yes.
We do have, our ordinance does say indigenous plants are recommended.
See,
It's in there.
it's because people don't read that I have to bring it up.
Or it doesn't say required, just recommended, but we could, that's where we are. Should we add the work approved in an application must be completed within, that's, you know what, whoever made this comment, that is already addressed in the municipal land use law. That sets the timelines and the time
Right.
limit at which the work must be completed.
Yeah, that was my comment. Yeah.
Yeah. So we do not need that in the bylaws.
Okay.
Okay. So are there any other changes to the bylaws? Can
Janice, can you go back to section 3:1:3-10?
There.
Okay. I think you need to clean up the first sentence in A. There's
Okay.
some deletions, but you didn't take out some other words, so it doesn't quite read. It's a little hard with all the deletions, but I
Well,
think,
here, let's try this.
yeah, if you highlight it and then accept
You.
for a quick second,
You.
it'll give you the pared down view.
Just click the little bar, click those little bars on the left, it'll go away temporarily.
Which
Those
bar?
the little vertical bars, yeah, click one of those.
Well, you want to accept the deletion.
Well, you won't accept it, it's just showing you, you can put it right back just by clicking the bar again.
I didn't know that.
So there's a clean copy, and you click it again, you get all the markup again.
All right, so we got it. This is what it would look like as a clean copy.
Yeah.
All right, so the board's meetings will be.
Okay.
Go ahead.
No, I'm looking at it now. It's like, okay, it looks like it cleaned it up correctly. Okay.
My only other comment was to add in the header for 1:3-11 at the top.
You mean in the table of contents?
Correct.
Yeah, I think I added that.
Okay.
1-. It's not in this version, but I did on the version that I have. I added that, so I will make sure that's in there.
So back at 1:3:10, Janice?
Yep, I'm going.
I'm-
1:3:10. Okay.
This is where I take the poll as to whether or not after that first sentence, the period belongs before the quotation mark.
No,
The period is after.
after.
Well,
After.
Before.
I think technically it's before, but it never looks right when it's before, so I always put it after.
I quote.
I never understood that rule.
I don't know if it's a rule. For me, it would be sunshine law, period, end quote.
Yeah, I think that's the way it is in the whatever the guidebook used to be called.
Elements of style.
Yeah, but it's
Period's
never
not
made
the
sense to me.
sunshine law.
Whatever.
Never made sense to me.
No, go back.
No, this looks terrible.
Yeah, undo that.
Undo
All
that.
right. There you go,
Like not
Arthur.
using an Oxford comma.
Overruled.
Did you say Oxford comma, Michael?
I said that's like not using the Oxford
Yeah,
comma for me.
that's Keith and myself's favorite thing, the Oxford comma.
It's right up there with native plants for me.
Oh, yeah. No, it's ahead of that for me.
Okay, so are you happy with the way this reads now?
Oh, we're so happy.
Yeah. I think it's okay for me.
Okay.
I want to see these again for another 10 years.
All right. Can I have a motion to approve the bylaws as amended?
So moved.
I guess I was going to say, can I have the honor of moving? You know.
Oh, yeah.
Okay. Okay, we have a motion from Mr. Jacobson. Can I second?
By Carmel.
Second.
Carmel. All in favor?
Aye.
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 Opposed? Abstentions? Okay. They're approved. They're now going to be off the agenda.
With special, by the way, with special recognition to Tony for suggesting what I think was a good idea, to be a little clearer about when we can talk and when we can't. So, I mean, you know,
Yeah.
I think this worked out pretty well. So thanks to everybody for
Great work.
working together on it.
No talking.
All right, so the next.
I just found something.
No.
Look in D&E, you need spaces before the paragraphs. So you can clean it up, just some spacing. Sorry. I'll keep my mouth shut.
I didn't think I needed board approval to do the spacing between the But I do, yeah, that drives me crazy too. Do we have a motion to pay the bills?
So moved.
Second.
All in favor?
Aye.
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 Opposed? Abstentions? Okay. And I
All right,
think
everyone, I think that's it. We
is
we have
it.
taken care of all our business. And thank you all for your participation and your attention and all the other good work that you do, have done in the past and that you will do in the future.
I'd like to thank Arthur. He had some good jokes tonight, I thought. They were pretty good.
All right. And I will move that we adjourn.
Second.
I'll second it.
All in favor?
Aye.
Opposed?
Have a nice July 4th.
Okay.
Thanks, everybody.
Enjoy the holiday.
God bless
See you next
everyone.
time.
Have a great day.
Thanks, Karen.
Bye.
Bye-bye.